Another thing that Samuel Kucheto says that I had made a suggestion that the people who have been affected, one of the redress, if they want, is to go and seek an injunction. I do not see how the Supreme Court is going to rule on this matter in a timely manner.
But you see how the injunction can be given in a...
Yes, so one recourse left to them is to seek an injunction.
Okay.
That would say that the Speaker's ruling should be put on hold pending the decision of the Supreme. And it's within their rights, and the law allows
Ceased and desist.
Now, yes. Now, Samuel Kucheto is saying that we should be careful and that Parliament is independent and all kinds of stuff. Who doesn't know Parliament is independent? But under our Constitution, everybody knows that no one organ is totally independent. You know it. You know this thing. Why are you coming to? Why are you forgetting these basic principles because you want to do some small propaganda? You know that under the three arms, none of them is totally independent. You know it. So if anybody goes to the court to seek an injunction, he is not undermining Parliament for you to come here.
I have been worried about how the Supreme Court, upon the invitation to meddle in, not meddle, the invitation to get into business of Parliament, has handled things. One example I can give you is when the President's powers under COVID, somebody went to the Supreme Court over it. The Supreme Court waited for over 2 years after the COVID and everything had ended and everything to now tell us that it was wrong.
You mean the emergency powers?
Yes. That it was unconstitutional. Meanwhile, people had been affected by the exercise of those powers. And why a person went to court was that the person believed that the thing was unconstitutional and was asking the Supreme Court to intervene so that people are not affected by an unconstitutional act. Yet they waited for all that period. Now, secondly, if you look at this this season disease issue, look, as we speak today, a decision by Parliament is being held in abeyance. For how long? For how long?
But right,
if you take the issue of
e-levy,
the e-levy,
people are paying e-levy.
So, as to whether something is constitutional or unconstitutional, a decision is given with alacrity. Another one is in abeyance for. It's troubling.
All these things that you are saying are good. There's no problem. I mean, the Supreme Court is subject to criticism. Okay? And so we can raise issues about their conduct. I mean, we all know that even the more graphic case is the George Amu case. We said that yesterday, I hadn't heard of him for a long time, somebody came to what they were talking about. Even the more graphic one is the George Amu case, where Georgia, 1996 or 7.
Yeah, it started from the High Court.
It was 1996 or 1997.
96 election.
96.
Or 97.
So let's say 90. So 97, George Amu petitions the court that I won the elections.
Not the High Court.
And even the Electoral Commission admitted that they did an error. They gave Amu's results to another party. They themselves wrote. And yet, we all know, it took 4 years when the Parliament that Amu was seeking there was over. So we can criticize.
So 16 years on from Amu.
So, one second. So we can criticize the Supreme Court. I don't have a problem. I mean, they are not at that.
No, 16 years.
But you would agree.
16 years on from Amu. 16 years on from Amu. A court decides to entertain and hear the SAL case. After over 3 years. Only to tell the parties that I don't have jurisdiction.
But I'm saying that we can criticize the Supreme Court. There's no, I mean, all of these things, we are not happy with it. The timing, I am looking at some reform that can introduce some time. Even beyond the Supreme Court interpretations. Ordinary cases at the courts. You have some ordinary case, land case, you are big A, so you know about land cases. It can go for 20 years.
20.
And then
50.
There are some
and then people, the parties die. You know, so There's so much that
and they keep overturning at every stage.
There's so much that we can talk about the judiciary and how to make it better. So that's not a problem. But as we speak, it is the Supreme Court that is seized with the power, the petition, and the law provides for it. So they may exercise that power in a way that we can criticize, like we are doing. We all do. But that doesn't take away their power to interpret. And when anybody goes to the Supreme Court to look for an injunction, it is also within their rights to look for that injunction.
Okay.
You know, I'm always saying that Bagme knows you'll get away with it because I don't see the Supreme Court sitting on this matter in 2 weeks.
But you see them injuncting his decision.
As for injunction, the nature of an injunction requires an immediate say.
If the Supreme Court will not be in a position to deal with the matter expeditiously in days, I don't even think that they should entertain an injunction. And I'll tell you why. In the case of the sexual rights, whatever, the
LGBT.
Yes. There was an injunction case before the substantive. The position of the court, chaired by the Chief Justice, was that when it was the ruling on the injunction was due, all parties had filed their processes and had done everything. Her decision was that she was not going to give the ruling, and that she would give it together with a substantive case. So in that particular matter, the Supreme Court declined to give
an injunction.
And the decision on that. And decided that they will put it together with the substantive matter.
And Doc, let me remind you.
And to that extent, the Parliament's thing is still in abeyance.
And you know that in the e-levy case too, we sought an injunction. The Supreme Court held that they would rather ask the GRA and the Ministry of Finance to keep proper records of everybody paying the e-levy. So they won't grant us the injunction.
But what?
So that in the event that the substantive matter is determined in our favor, then there will be refunds.
But Randy, what we are talking about...
Can you believe that?
So they can calculate my e-levy after.
Can you believe it? Yes.
What we are talking about is the Supreme Court ruling on an injunction.
Yes.
We may disagree.
No, those are the examples I've
given. But I'm saying, I'm saying they are perfect. But it tells you that they ruled on an injunction. And they said that this and that. But the point is that they ruled. They gave a ruling.
No, they didn't. Okay, they gave a ruling, but they didn't
grant.
They didn't grant.
No. They didn't rule on whether we are granting or not granting.
Yes.
They said that we will not.
But that's a ruling.
Announce the decision.
That's on the LGBT.
We will add it to the substantive matter.
But that is a ruling. That is a ruling.
Yes.
So basically, I don't say anything. So that injunction option is left to the parties concerned.
All right. Okay.
Yes, they can go and seek an injunction.
So,
if they do that, when they do that, they haven't undermined Parliament or anybody.
All right.
They are just exercising their right to the rule of law.
So
get away from that.
No matter Nana Akomea's gymnastics.
So, let's get on.
No matter his gymnastics. No matter his theatrics. We are the majority. And we are going to be the majority, inshallah.
As we speak, the speakers ruling.
So this all this
but we have all agreed
trying
that
to,
in pursuit of the rule of law, the speaker's ruling holds. It holds. So why are you telling me I'm doing that?
We are the majority.
So why is he telling me?
All this,
we have agreed on the substance.
But you started by telling him that they can't do focal with their majority.
No, you said focal.
Oh.
Look, just to settle a matter on the Afenyo Makin intervention. You know, it sought to create the impression that after rulings of speakers, the convention is that leaders are allowed to make comments or to debate it. The speaker rightly checkmated him and told him that there is no such convention. He has been in the House since 1993. And indeed, if you look at this Hansard, as soon as Speaker Okwe finished his ruling on 7 November 2022, he moved to suspend sitting. No leadership was allowed to make comments. So what he was seeking to do, you know, that's the convention, the speaker must allow me to speak. He was totally out of order. And it was not consistent with parliamentary procedure. And the speaker put him in his place. So you are trying to distort matters and you are just being unfair to the speaker.